that big boss less special. It ain't no game, but they saying welcome to the second level. Second level. Second level gaming. Second level.
Hey everybody. Up next, we're going to be hearing from Ben Siders from Lewis Rice, who Lewis Rice is also a sponsor of our after party tomorrow, so if you haven't got a chance to take a look at that, take a look at that. Ben is going to be doing a talk over using music in video games, legal issues that you need to know. Without further ado, here is Ben.
Thank you. All right. Can you guys hear me okay? Because I can't tell up here what you can hear out there. Is this all right? Good. I see a thumbs up. All right. Well, I am Ben, and this is a boring slide. This is a much more fun slide of me. So I'm a lawyer. I work here at Lewis Rice here in St. Louis. As James said, we sponsor the festival and, the party tomorrow, which I will be at. So if you have more questions and you can't find me today, come to the party tomorrow. Why music? When the call went out for topics to discuss, I wanted to do music. I don't know if it's been covered all that well at Pixelpop. I don't think it's covered well in the industry generally. And I got into this because about a month ago, at the end of June, all the lawyers in Missouri have to get our continuing legal education hours in, and I was way behind on the year. And you got to get 10 a year plus 2.5 hours of ethics. So I had to find one day to cram in an entire year worth of continuing legal education. And the Bar Association did a CLE on the Beatles and ethics in representing bands. Although I don't represent bands, I thought, well, that's way more interesting than, secured transactions and that kind of stuff. So I did that CLE. It was about music copyrights in general. I'm an IP lawyer, so I found it fascinating. I decided to make that my topic for today. My main concern, and this is a picture of me in 1992 trying to learn how to play the accordion. So I am an IP lawyer, like I said. I'm also a musician, not much of one. I was at one point an accomplished jazz trumpeter. By accomplished, I mean I was in jazz band in high school. And then I also play the guitar, dabble with the piano, and if I could ever find my mother's accordion again, I'd play that too. The reason I want to talk about music, though, is because it's really hard, which I didn't appreciate that well until I did my CLE a couple months ago. It's very complicated. It's very, it's not intuitive. And the consequences of screwing it up can be extreme. So under the Copyright Act is the law that governs all of this. And if you are accused of copyright infringement, the penalties can be as high as $30,000 per infringement. And in music, that's per number of times it's been played. So think about a game you make, how many times all of your players collectively have played any song that's in your game. If it's not licensed correctly, every single one of those is $30,000, as much as $30,000 in damages. You're out of business, okay, you're bankrupt. So that was kind of my motivation for doing this, this talk. My other motivation was this quote I found from Todd Brabeck, who I don't think he's with ASCAP anymore, but he was for a while. I'll let you read that. I won't read it to you. The important part is the very last phrase where he says, the video game industry represents a new and valuable source of income. And now, those of you who are not lawyers probably read this and said, well, yeah, because they want to come to us as video game designers and have us license their music. But lawyers look at this as a threat, that we're going to go through all your games and find all the mistakes you've made, your technical mistakes and how you've licensed your music, even though you tried in good faith to do it right, and then cram the law down your throat and try and get more money out of you. And part of this is me as a lawyer being paranoid. Part of it is that this actually happens. Okay, so what I'm going to talk about is you can't understand what you need to do to license music for use in your game correctly unless you have just at least this much knowledge of copyright law. And I'm telling you, I'm condensing 4 hours of material down to 20 minutes here. So if any of this doesn't make sense, this is the first time I've tried to do this quickly. So if it doesn't make sense, come talk to me afterwards, and I apologize in advance. I'm sorry, I got to follow up my notes over here. So like I said, we're going to talk about copyrights really quickly. So music and law together. Still have to juggle. So this is an actual law of the United States. This is part of the Copyright Act, Section 102. It defines what kinds of things you can get a copyright on. Now, who's heard of a copyright, first of all? We've all heard of copyrights, right? Because we've all uploaded stuff to YouTube and it gets taken down. Okay. So the Copyright Act protects creative work. It's not like patents. Patents are about inventions and functional things. Trademarks are about branding. Copyright is about creative work, source code, art, music, movies, film. These things are all subject to copyrights. But not everything under the sun is copyrightable, and this is the part of the law that defines what is. And for our purposes today, we're going to talk about two parts of it. One is section 2, musical works, including any accompanying words. Why we can't say lyrics, I don't know. And then 7, sound recordings. And this should present the first sort of question mark in your head. Why are those 2 different categories? What's the difference between a sound recording and a musical work? Aren't they the same thing? Well, sound recording is a little broader. We have a tape going right now, so there's a sound recording of this presentation, and this is not music. But if you perform a musical work and record it, you have a sound recording. So the important thing to take away from this category is that a song in America, under American law, has at least 2 different copyrights, a recorded song. One copyright is in the underlying musical work, the melody, the tune, the vocalization, and that's on the left. That's the sheet music for Hey Jude. And that's what I call a composition. I think calling it a composition is easier to understand this difference than calling it a musical work, which isn't even defined in the Copyright Act. So a composition, circle C copyright, is the song in the abstract. A sound recording is a recording of somebody performing the composition. And so you can see here I've got Abbey Road, which I don't even think has Hey Jude on it. I probably got the wrong album there. But the sound recording is what we call a phonograph or a phonorecord. So if you ever see the reference to a phonorecord in the Copyright Act, that's what circle P means. If you see that on records, that's a recording. 2 different things. All right, so what does this have to do with copyright? Why do we care so much about these 2 different things? The reason is, well, I'll get to one in a second, which is you've got to license them both if you want to use the sound recording. But the other is what you can do as the person who owns these rights is different for a song than for a recording of a song. And in major music production, those 2 rights are owned by completely separate groups of people. So you have to go to both to get stuff. And we all think of songs in mainstream music as what you hear on the radio, right? So if I say, who's heard of the song So I Will Always Love You from that movie The Bodyguard? You guys remember the song? Who performs it? Whitney Houston, right? Who wrote it? Dolly Parton. Very nice, very nice. Yeah, so Dolly Parton owns, if I go back to my Dolly Parton owns this part. Oh no! Dolly Parton owns this part right here, but Whitney Houston's estate owns the recording of her performing it. That's an important difference. So if you wanted to use any old recording of So I Will Always Love You, you have to get permission from Dolly Parton to do that. If you want to have your own cover band record it, that's all you need. You just need to hire a band and record it. If you want to use Whitney Houston's version, you need both Dolly Parton's permission to use the composition at all, plus Whitney Houston's permission to use her specific recording. And these rights are called publishing rights for the song in the abstract and master use rights for a recording of the song. Now you guys are most likely, if you're making games, not going to be going to the AAA equivalent in the music industry and saying, I want to get a copy of your big radio hit. You're not going to be able to afford those licenses most likely, so you're probably not going to do that. However, if you happen to, it's important to understand these differences. You're more likely going to go to an indie developer or a musician or an independent artist or just license something you find online. In those cases, these 2 sets of rights usually are owned by the same person. So if you sit down with a guitar and a 4-track and play a song and record it, you have created the composition and created the sound recording of the composition at the same time. And so the same person would own all of those rights. All right, moving on. Okay, so what can you do? For both compositions and sound recordings, the author has some rights in common and some that are different. So both have the exclusive right to reproduce the song in phonorecords, the exclusive right to prepare derivative works. This would be what Weird Al Yankovic does. I'll talk about that later. To distribute phonorecords to the public. And number 4 is important. In the case of musical works that are in there, to perform the copyrighted work publicly. So if I got my phone out right now and started playing a song that's on my iTunes, I have performed whatever that song is publicly. I would need permission if I was to play Hey Jude for McCartney and Lennon, or I guess Yoko Ono now because Lennon's gone. But I would not need permission from Harrison or Starr because they own rights in the performance, not in the underlying song because they didn't write it. And then number 6, in the case of sound recordings, this is the only sound recording right, other than the 3 main rights that exist, to transmit or to publicly perform by means of digital audio transmission, okay? So what this means, practically speaking, sort of as an FYI, if you hear a song on the radio, the performing artist got 0 cents for it, not a dime, not nothing, not nada. Performing artists get nothing for radio performances. But digital transmissions, they do. They get about 1/120th to 130th of a cent. So they got to play their song hundreds of times, or stream their songs hundreds of times, or of $1, sorry, to get $1. So digital transmissions you can't get paid for. Skipping along. So what does this mean to you? This is how the music industry works, okay? So if you want to go perform a song, here's who you have to talk to. Once you want to use a musical work in synchronization with any kind of moving image, whether it's in a TV show, a movie, or a video game, you need a special kind of right called a synchronization right, or a sync right for short. So if you're going to any of these websites that have free music for use in games, and you go click through the license, if it doesn't have the word synchronization in there somewhere, you don't have the right to use it the way that you need to, and you could be getting yourself into trouble. So what can you do, or how do you license this stuff as a practical matter? I should mention here too, the scope of, you may need other rights besides synchronization rights, and what those are depend upon how you're going to use the game. So for example, if you're going to go to like here, you're going to exhibit a game here at Pixelpop, okay? This is a public or quasi-public event, so you would need the public performance rights from the songwriters to have your game here and to have the music in it played in this forum. So that's important to understand. Now, let's talk about actually going through the licensing. So if you're going to use a recording that has already been put down by a performing artist or even the original composer, you need two sets of rights, like I said. You need the publishing rights from the songwriter, and you need the master rights from the person who recorded it. But under our laws, you can also go record your own cover, which just requires publishing rights. Also under our laws, they can't not give you that license. It's called a compulsory mechanical license, and if you go to the publisher and say, I want to record a cover of pick a song, they have to give you the license. They can't say no, it is required by law, okay? So if you're curious about that, Google compulsory license or mechanical license. The reasons for this are very old. They do have to go back to the player piano. I'm not going to get into it. So that's important to know. That's how cover bands get by. All you have to do is just pay, it's cheap. It's like, I think it's $1.87. It's not that much. So you can always hire your own band or just record it yourself if you're a musician. There's a third option, which is the option I like the best for how you get music into your games. Don't pay the man, be the man, all right? Find a local musician or a local composer, have them put together an original composition for your game. You'd be surprised how affordable this is and how quickly a good composer can put together a snappy track. And then you can have the composer or another performing artist record it, and then they transfer the copyrights to you, and now you own the publishing rights, you own the master use rights. You don't have to get licenses from anybody. You just own all this stuff yourself. And there's a famous quote from Paul McCartney. He was interviewing Michael Jackson in the 1980s, and Jackson asked Paul McCartney, what would you do differently in your career? And he said, well, I wish I'd paid more attention to my publishing rights because that's where all the royalties come from. So Jackson bought all the publishing rights to the Beatles' entire catalog, which I thought was funny. It did, yeah, it did. And then when Jackson died, Sony bought the publishing rights, but there's a reversionary clause in the Copyright Act. And last year, McCartney sued to get all his rights back, and Sony had to give him up in a settlement. So it was up until 2017, the rights to the Beatles catalog was still being litigated. It's crazy. All right, derivative use rights. I put this in here because I also have a picture of me playing the accordion. I thought this was a nice way to bookend this talk. This is Weird Al Yankovic. Parodies are different. So everything I talked about is to perform the song as it was written, or to use a recording as it was written by the original songwriter. But if you're going to change something, then it could become what's called a derivative work or derivative use. And a derivative use is where you've changed the song enough that your new version is actually separately copyrightable, right? It's a new creative work on top of the original. So Weird Al, obviously, changes the lyrics. He writes a whole new song. It's the same melody. He might play it polka style, but he also writes all new lyrics. So his uses are not just publishing rights, and then he does a cover. He's not doing covers. He's making new songs. So if you want to slice and dice the song as recorded, you can usually do that. That's what sampling is. And for sampling, you need the master use rights of the original unless you're going to record your own. But if you're going to modify the song in a way that changes its overall character, its overall feel, you're going to re-record it as a polka song, do new lyrics, change the melody in some way, then you need derivative use rights. Those do not come by default with most licenses. You need to pay more attention to the details of the license and whether those rights are included. So here's an example of a sync license. This is not actually for use in the game, although this license would be appropriate for use with the game. This is an actual license that I dealt with in a litigation context. There's a couple things I want to point out. Number one is that we have the magic word synchronization in here somewhere. Where did it go? Grant of license. Stay, laser, stay. My laser won't stay. All right, well, under section 2, where is it? Synchronization. I know, at the bottom, the last part of section 2. Synchronizing. Those are the keywords that you need. You need to have the right to synchronize with whatever you're doing. So your license needs to have that. You'll also see other magic words from the Copyright Act in here under section 4. 1, distributing. Okay, so you've got that right. 2, public performing. You've got that right. 3, more distribution rights. This one is in physical media. And 4, causing and permitting others to distribute and publicly perform. A nice broad license. And you see at the top, small business, up to $20 million a year. And under section 2, the license is only available to those who earn less than $20 million a year. Does anybody here not qualify for this license? I would assume so. If you don't, then you're in the wrong talk, all right? So this actually was litigated, though, for 2 reasons, and it was clause number 4 there at the very end, where it says causing and permitting others. What if I allow Walmart to post the work that I made under this license on their YouTube page? 4 says I can do that, okay? So the license grant is to 2. They're granting a small business the right to allow somebody else, with no limitations on how big it can be, to post it. So that happened. What do you think happened? You think the licensor was like, yeah, that's what it says. That's fine. I'm not going to come after you and try and screw you for more money. Think that's what happened? No, of course not. They went to Walmart and said, Walmart? It wasn't really Walmart. I'm using them because they're easy to think of as being evil. Walmart, why are you doing this? And Walmart's like, well, we got it from this game company over here. Go talk to them. And of course, you've got a relationship with Walmart or Target or whoever it is to preserve. And so you want to work with them and get this taken care of. From their point of view, they didn't do anything wrong. And so we threw this license up and said, well, look, it says you can do this. And they're like, no. You have to read number 4 in conjunction with number 1, even though number 4 doesn't say that the third party has to be a small business. That's what we meant. Since it's vague, you wind up in that situation where up to $30,000. So you should be willing to pay up to $30,000 to get out of this mess. Also, if they have to sue you under the Copyright Act, you have to pay their lawyers if they win. How interested are you in paying Sony's lawyers for winning a case against you? Not interested, okay? So key takeaways for video game developers. 1, you need a sync license to the original composition at a minimum. If you're using a prior recording of the composition, you also need a sync license to the master. Consider collaborating with an indie musician or a local artist to create an original work for your game. You should pay them. You want to get paid for what you do, so do they. You would be surprised, though, how affordable this can be. If you license an existing work, make sure you get all the rights you need to use the work in the way that you want to use it. And the only way you can do that is run the license by a lawyer. I realize it's a self-serving statement, but you don't have to hire me. Hire somebody to look over it and make sure that it's all done right. All right, so I'll do questions in just a second, but some real quick hits on how you can find me. This is me when I was slightly fatter, only slightly. That's my Twitter. That's our law firm and our IP department. I also have a podcast called A Lawyer's Guide to the Galaxy, where we cover various nerd things in context of law. We cover video games pretty frequently. On here we have 4 episodes we did that involve games, 1 on clones, 1 on Minecraft, 1 on RNG and loot boxes, and then the one on the bottom right is board games. We covered this time TSR, tried to trademark the word Nazi. So there's that, and I've got time. I can't believe I got through all that in time. So questions, anybody have questions? Yes, sir. Yeah, so, yep. Yeah, so the question is, what about public domain music, things that predate 1920? So our current copyright laws are very long, and copyrights for things that were made prior to about 1923, I think, are public domain. So if you have a recording that's good enough to use in your game that was set down in 1912 or something, of a song written before that, then it's not copyrighted anymore. The copyright's expired, and then you can do whatever you want with it. I would be cautious, though. There's not much that survived that was recorded long enough ago to be in the public domain. Recording technologies are still relatively young, so be very careful with that. Particularly if the recording has since been rearranged or remastered or redone or otherwise polished up, it is possible that somebody has come along later and the version you have is copyrighted, even though it includes somebody else's an original public domain work. So like if you've taken a college course, you have to buy like a fiction book. You get Shakespeare, And obviously Shakespeare's not copyrighted anymore. Actually, it probably never was. But they put a bunch of cruft at the beginning and the end to put something copyrightable in there so that they have a copyright to their arrangement and their annotations and that kind of thing. So it's not always as simple as it seems. But if you can find a true original recording, then yeah, it's public domain. Yeah, and the sheet or the composition, then you can just perform it yourself. Yeah. You see, Hollywood does this a lot. All these public domain movies, the Jack and the Beanstalk, and all these, Grimm's fairy tales. We're making all these movies now based on things that are public domain, so they can not have to get the rights to them. So you can do the same thing with music. My time is up. I'm sorry. If anybody else has questions, I'll be wandering around over here, and I'd be happy to talk to you. So.
It ain't no game, but they saying welcome to the second level.